Hello, everyone. Welcome again to our faculty scholarship in 10 questions. I'm Dana Neacsu, the director of the Law Library, DCLI, here at Duquesne Klein School of Law. And it is my privilege to invite Professor John Rice to discuss his scholarship with us. First of all, I want to ask you whether you are connected to a John Rice, who was in practice as a solicitor in 1782 in London, who then sailed to Philadelphia in 1784 and became the first the first Attorney General of the territory of Indiana.
I am not to my knowledge.
Oh, right.
But that's pretty awesome.
Maybe you should look into it. So let me tell you a few, this will be cut. So let me say a few words about Professor Rice before we are going with question one. A native of Greenville, South Carolina, John graduated cum laude both from Clemson University and from the University of Tennessee College of Law, where he earned the college's concentration in advocacy and dispute resolution. And that happened barely 10 years ago. So John was one of the 10 law graduates nominated to the Order of the Barristers and was awarded the ABA Scholarship in Leadership by the College of Law faculty. Among his many other achievements as a law student, I would add that John competed nationally at Brooklyn Law School in New York City, and that he served as president of the Student Bar Association and as vice chair for the Moot Court Board prior to joining Elmore Stone and Caffey in 2014. Also, I would add that John served as a judicial law clerk for the Honorable
Sharon Geely
of the Supreme Court of Tennessee. Moving forward to his years in private practice, John handled complex litigation in such areas as medical malpractice, products liability, and commercial matters. Finally, bringing his remarkable achievements to Pittsburgh, currently John Rice is our visiting assistant professor of law. And I will stop here with the first question. If I haven't embarrassed you enough, how would you like to introduce yourself, John?
So I like to think of myself as a teacher scholar, and much like Ashley London in the last session, I am not your typical candidate for this position because I did not go to one of a few select schools. I did not clerk for the federal courts, but really I developed my interest in teaching and scholarship by working as a lawyer, seeing the opportunity that people in this position have to train future lawyers and influence the profession. And that's really what drove me to move from practice into where I am now. And I like to think of myself as a teacher scholar where both of my teaching and scholarship serve the same purpose to further the profession and make our world a better place, I hope. And I think my teaching and scholarship broadly surrounds the issues of business and social change.
I would like to commend you and your scholarship on your courage and transparency and the ability of promoting a big picture view of society, working to foster social change, but also an exceptional attention to detail to whatever law has in terms of technical aspects. I think this is quite unique. So I think that's something I would like to further discuss with you. Question two, what inspires you to write?
Well, I think maybe I think I received my inspiration from three things. And the first is that I write for the same reason I teach, and that is that I want to develop the profession and I want to develop the future of this profession, recognizing the power that it has over society. The second reason that I teach and the second reason that I write is that I have something to say. and something that I think is important and something that I want to put out there. And the third one is kind of the other side of the coin, and it draws from my days as an advocate that I feel like there are things that need to be heard, and that there are people who need to be saying things and speaking up and challenging the ways that we engage in business, the ways that we structure ourselves as a member of society, and the way that we treat people. So there needs to be people who are speaking to matters of inequality and injustice, and speaking to abuse and oppression. And I don't know if I'm courageous. I don't know if I'm the best one to have these conversations, but it is something that I feel strongly about. I feel like I have something to say, and I feel like there are things that need to be heard, and there are voices that need to be spoken for.
Using your own words, John, from A Victory for Equality of the Rule of Law, I would like to thank you for your courage and veracity for bringing these issues to the table and willing to engage with us for the benefit of our community here at Duquesne. Thank you. We are moving forward quite steady. Who are your favorite legal writers?
That's such an interesting question, because the areas in which I write about are very diverse areas. And so when I write about business law and corporate law issues, I look to voices like Ann Lipton at Tulane. I look to people like Jessica Erickson at the University of Richmond. I really appreciate the work that they have done in the business and litigation space. Lisa Fairfax, who's at the University of Pennsylvania, and is probably most famous beyond the legal academy for being the law professor who introduced Ketanji Brown Jackson at her confirmation hearing, has written a tremendous amount about shareholder activism. And especially as I was working on my rainbow washing piece, I found a lot of her literature and a lot of her work as a really useful, thoughtful, and intentional literature on that. And so I appreciate the work that she does and the leadership that she provides. When it comes more to the sexuality issues, I would be remiss to not recognize Polly Murray as really somebody who was before her time and has become a huge and prophetic voice in the space on race issues, on gender issues, and on sexuality issues. And I mean, she was in the trenches back before the trenches were really a place to be, and was doing a lot of the work that Ruth Bader Ginsburg got public credit for. Polly Murray was right there with her and actually was credited on some of the briefs and the cases that Ruth Bader Ginsburg argued. I have really appreciated the work of Marie Amelie George at Wake Forest, who writes about social issues around sexuality, and it has been really what I have found to be a leading voice in stating the state of where things are, but also recognizing the hidden forces behind what's at play. And so I really admire that work as well.
Thank you, John. You mentioned the rainbow washing, and my question number 4 is, what piece of your scholarship would you like to talk about today?
So rainbow washing is a piece that I have been talking about quite extensively over the past year. And rainbow washing explores the legal problems that arise in the context of public corporations when corporate managers make public-facing statements of support for the LGBTQIA plus community, and then they either engage in conduct that is just not in support of it at all, and they kind of remain neutral on those issues, or they're even more disturbingly engaged in conduct that is directly contrary to the interests of those communities. So on the one hand, the corporation is trying to use its support and stances in favor of this community to make money, to attract investors, to gain standing in communities, to get benefit for themselves.
Exactly.
But then on the other hand, they're either failing to act in furtherance of that, or they're actually acting hostilely to it. And the easiest practice to point to of that is the way that a corporation engages in political donations. And so I was able to identify instances where, for example, CBS signed on to the Human Rights Campaign's statement of businesses opposed to anti-LGBT legislation, while at the very same time they were making donations to politicians in Texas, Tennessee, and North Carolina who were behind the so-called bathroom bills. Of course, that's something you have to dig for. They're not as apparent about that. They don't want you to know about that, but they want you to invest. And I think that raises social problems and it raises legal problems. And as the former litigator, I wanted to think about how shareholder litigation could be a tool for combating that practice. And so in rainbow washing, I try to articulate why this practice is socially problematic and also why it's legally problematic. I attempt to articulate theories for why this conduct is breach of fiduciary duty. And then depending on the circumstances in which the communications are actually occurring, could rise to the level of securities fraud. And then I try to articulate what claims could be asserted by shareholders on those bases, and then anticipate the challenges the shareholders would face in trying to bring those claims.
I want to applaud you on writing such a, how shall I say, clear, concise, persuasive piece of a scholarship on such in this area where it's needed. More needs to be done. I was trying to see who else wrote in this area, and you're among the very few, or the only one, and that's deplorable. I'm sorry to use that word, but a connection that is dear to my heart. So in your article also, you explain how it started with whitewashing, covering damages, and then to greenwashing. And you bring it to rainbow washing. And going to, if you want to explain a little bit more, to derivative shareholders actions, because I'm so excited that recently the Shell Corporation was sued by a shareholder. The directors, the board of directors were sued by a shareholder, Earth client, in the highest court in Wales. So how can we make this society a better society in terms of social justice, incorporating your interest in rainbow washing, but also when you talk about the rule of law, that only one thing I'm going to use your words, you're using the Bostock words, that only the written word is the law and all persons are entitled to its benefits. So how do we bring everything back to what you're saying? That's a tall order of a question. And I think I hear at least three separate questions. Yes. And so the first is, what exactly is this washing terminology we're using? And then how might it support a derivative action? So what is a derivative action and how do those come into play? And then finally, how do they tie into matters of the rule of law? Thank you. And so let's talk about the washing issue first. And the language of washing has been used broadly, but it really relates to the domestic practice of, say, you're preparing to sell a house and you realize that you've got a big hole in the wall. And having the hole in the wall is not necessarily a problem, right? We can have holes in the wall as long as we let people know there's a hole in the wall. The context of whitewashing, though, is where you do a cheap fix, you paint over it so that anybody who's looking at it doesn't know the hole is there. And that's essentially the problem. The fundamental problem with whitewashing or any type of washing is deception. Because you cannot address the issue. And it might change the value of the house. Like if I knew that I had to take on a house that needed significant repair,
I would pay less for it.
Absolutely.
And so if I look at something and based on the position where I can be, if I can't tell the true state of things, then I don't know its approximate value. And that becomes really important in the investing context when we see more and more trends of people making investment decisions based on their values. Not just based on how can I make the most money, but kind of the adage of how do I do well while doing good. And
we want that.
We want that. That's wonderful.
Excellent.
And so this context of whitewashing, or this idea of whitewashing, has been applied in various contexts. And it can be probably the most pop culture use of it is where we have a movie or a television series that is bringing a book to life or documenting a historical instance. And they take a character who in the book or in the instance was of a different racial group, and then they cast a white actor to play that person instead of somebody from that group themselves. Or they try to sanitize the story and really put a spin on it that, makes the white community look better. And so the whitewashing has led to other instances, and greenwashing is probably the one that has gained the most attention. And greenwashing has largely been raised in the context of consumer protection. And the context or the concept of greenwashing refers to when a company presents itself as environmentally friendly, as engaged in sustainable efforts for the purpose of appealing to people to whom that is important, when in fact their efforts are exactly wrong. And Miriam Cherry has written some incredible law review articles about greenwashing and the BP oil spill, and really has had quite a bit to say about that. Other people have looked at diversity type washings and the consumer protection actions. But as far as I'm aware, I'm one of the first to explore the implications of fiduciary duty law and securities law of these sorts of practices. I had a very difficult time finding other legal scholars who had really delved into those issues.
I have to say that I tried to find someone else, I couldn't. Yeah. And knowing that you thanked all of us here for support with the research, you are so generous.
Yeah.
I want to say that indeed your efforts of not finding someone else, we didn't find anyone, so we want to congratulate you.
Thank you. So, and some people have explored this more from a public relations concept, but nobody's really looked at it from a litigation concept. So I think that takes us to the next question about what is a derivative action. And when we talk about corporations, it's kind of important to remember that when we have corporations, they are formed under the laws of various states. Most commonly public corporations, which are corporations that stock is bought and sold on public stock markets like the New York Stock Exchange or NASDAQ. Most of those corporations are incorporated under the law of Delaware. And the kind of the traditional sign of a corporation is that we have a split between ownership and control of the corporation. So the stockholders own the corporation in a loose sense. And I have plenty of colleagues in the corporate space who would say, do they really own it? And I bet Professor Herman would come in and say, what sticks in the bundles do the stockholders really have? Can they walk in and just go into an office? Like we could get into that debate, but the fact of the matter is that they own it in the sense that they have the equity interest in the corporation. And then the business and affairs of the corporation are managed by a board of directors who have the prerogative to appoint officers. And so we get into this class, the split, where we've got the stockholders who are happy to get their dividends. They are kind of over here, they're passive people, and the directors and the officers are really responsible for the conduct and affairs of the corporation's business. Back in the day, and I would say the 1930s, kind of in the wake of the Great Depression, when we really start to see corporate law and securities law develop, most people were okay with that. They were okay to just get a check in the mail, have their money, what have you. as we move through and we get into things like World War II, and then we get into apartheid in South Africa, we get into the civil rights movement. I'm not going in historical order. We get into the Vietnam War. All of a sudden, we get into the rise of environmental regulation in the 70s. That's a particularly key one, where people's values that we want to take care of the environment began to expose corporations to fees and penalties from violating government regulations. We began to see a change in the way that the shareholders engage with the corporation. And now they're no longer interested in just sitting on the sideline, but they're interested in how is the corporation actually being managed and how's it interacting with various other stakeholders in the community. And so when a shareholder objects to something that the directors or the officers are doing, we run into a problem in the sense that if the corporation let's take a step back and say, if the directors or the officers were breaching their fiduciary duties to the corporation, then it's really up to the corporation itself, up to the directors and officers to file suit.
Absolutely.
But we run into a very practical problem because the directors and officers aren't going to sue themselves. They're not going to say, we're breaching our fiduciary duties. We are going to sue ourselves. And so what the Delaware courts and courts across the country and really internationally have done is they've developed this equitable remedy of a derivative action. And it allows the shareholder under certain circumstances to commence a lawsuit against the directors and the officers in the name of the corporation. And so I tell my students, it's kind of like the shareholder puts his hand up in the puppet and tries to take control. And a derivative action is really two lawsuits in one. It's a lawsuit by the shareholder against the corporation for the harm that's being done. But it's also an attempt for the shareholder to step into the shoes of the corporation and sue the directors or officers to either receive damages for their breach of fiduciary duty or to compel the directors and officers to take action to fix it. Now, with derivative actions, we run into this tension where the business and affairs are managed by the directors, the shareholders only passive, and quite frankly, the laws surrounding the directors, the officers' fiduciary duties are very deferential to the directors and the officers. So the burden of succeeding in a derivative action is quite high. But there are instances where you can show, especially when it comes to matters of loyalty, for the fiduciary duty of loyalty, that we can't expect the directors to sue themselves. And so the derivative action is the best, if not the only way that shareholders can take meaningful action against the directors to address those issues.
I'm going to push you a little bit further. So the way I see it, when directors fail to take action according to whatever they set themselves up to follow, there is a risk that they don't manage.
Yes.
Or if you want, multiple risks. If I don't follow and fulfill what I tell the public I will do, there is the risk of losing the trust of the public.
Absolutely.
And additionally, more specific, technically losing the trust of the people who invested in my corporation. So on one hand, the public at large is going to boycott CBS, hopefully. And the people who are investing their money into CBS, they're going to say, if you say one thing, and I'm using that as an example, they're by far not the only one.
Sure.
So there is this, I think is problematic, and I like what I hear, because there is a social risk that corporations are failing, the directors failing to manage. And we are not going to achieve what I believe everyone's here's goal is, to reach a more just society.
I think that is true as a social problem. I think when we try to analyze this as a legal problem,
Yes.
It becomes a bit more nuanced, because we have to figure out precisely what is the claim against directors or the officers.
And that's why I love your work, because you can always bring people down to earth.
What is the claim? And so with fiduciary duty, at least under Delaware law, the Delaware courts have recognized that directors and officers owe two fiduciary duties: the duty of care and the duty of loyalty. The duty of care tends to be implicated when the complaint is that the directors or the officers just made a bad decision. You know, you did something, it was wrong, it was bad, you got hurt because of it. Claims under the duty of care are very difficult to prevail under because we have this highly deferential business judgment rule. The business judgment rule is a recognition by courts that, number one, courts don't have the expertise to be making business decisions. And number two, we shouldn't be judging business decisions in hindsight based on whether it turned out well or it turned out poorly, but we should really assess them procedurally to see, did the directors or the officers, when they made the decision, were they fully informed of the material facts? Did they inquire and make sure they had all the relevant information? Were they disinterested, meaning there was no conflict of interest? And did they make a decision that at the time they believed was in the best interest of the corporation? So that's the business judgment rule. It's highly deferential. And I tell my students that if you have a plaintiff who is raising a claim for breach of duty of care, just based on a bad decision, we call that plaintiff a loser because they're not going to survive. They're not going to survive a motion to dismiss because the business judgment rule is going to swoop in and protect the directors and officers. Now, if they weren't reasonably informed, if there was a conflict of interest, then we actually begin to talk about the duty of loyalty. And the duty of loyalty is a place where shareholders actually can and do prevail in derivative actions against officers and directors. And to prevail under the duty of loyalty, you either have to show that there was a conflict of interest, that the directors or officers usurped or competed with the business and business opportunities, or that they failed to act in good faith. And the failure to act in good faith has been defined as sustained and systematic failure to exercise oversight or reckless or conscientious disregard for their duties. And that's where we can find a lot of the ground for these greenwashing, rainbow washing claims to say that they're being deceptive. They are lying. They are taking advantage of these things. And a lot of those can be rooted in this good faith aspect under the duty of loyalty.
I'm happy that you ended your explanation on an optimistic note.
Yes.
For a moment, I was afraid.
Well, I mean, there's a realism here that we have to recognize that these are uphill battles, but they are battles that can be won. And very often, when we're talking about corporate governance, we fall into the trap of thinking that the goal of litigation is to reach a judgment and to get damages. But we forget that just the mere existence of litigation in and of itself is a problem for the directors and officers. And the litigation can be used as a tool to force change.
Absolutely.
And so if you can survive the motion to dismiss, we really don't have to worry about getting to a judgment, because once we survive that motion to dismiss, we have more leverage, we have a place at the table, we can engage in other types of conduct to get the change that we want.
Thank you so much. I hope that people who are watching us have understood the lesson. That was very clear, and thank you. Moving forward, what are the main ideas behind your scholarship? You have reached on some of them, and I commend you for your interest in both business and social justice, which is unique also with the fact that you're interested in so many aspects of social injustice, and you're determined to participate in the huge effort to redress them. So in addition to this, if there are any other ideas that you would like to share with us.
So it's so interesting to me to hear people be surprised by that. And I frequently have people say to me, oh, well, it seems like your scholarly interests are corporate law and queer issues. And they try to put them into two different camps. And I always resist that and want to respond to that and say, when we think about the key role that corporations occupy in our societies and the amount of power that corporations have to influence lives, to influence decisions that business leaders are making, we can't help but understand corporate law as a piece of social justice. And to try to siphon them off is really, I think, short-sighted.
Would you like to elaborate a little bit more? Because I think even that is an amazing position. I'm going of full disclosure. I haven't heard this type of talk when I was at Columbia. So I would like to encourage you to explain to maybe people from Columbia Law School would like to hear you.
Well, let's go back to the day where corporations were primarily formed for the purposes of railroads.
All right.
And the railways. And the amount of human rights violations that were occurred there, deplorable working conditions. We can get into some discussion about the black banks in the early days of the banking for the African American community, where the government chartered a national bank specifically for African Americans who had received payments after the Civil War. They put it in the Freedmen's Bank, and then the Freedmen's Bank was investing all this money in the highly risky speculative railroad companies. I mean, it's a tale as old as time as we go back and we see the tension between wanting to make profit and the way that you can make profit through engaging in exploitive behaviors. It's just ingrained in it. And so we can't siphon it off. We can't put corporate law over here and social justice over here, because the fact of the matter is they're inextricably interwound.
Especially now.
Especially now. And we can look and we can talk about ESG, which is kind of the hot topic right now. And all of the ESG, that is the idea that corporate directors, in addition to making profits for shareholders, should be thinking about environmental, social, and governance issues. And perhaps even that there could be instances where ESG issues or environmental, social, or governance issues would require making less money for shareholders.
I love that. I love that very much, because it seems that we don't understand that every single castle that we build requires everyone else to participate in building one castle.
Yes.
We cannot continue on this path.
No. And we also can't ignore the fact that we can look at the BP oil spill and say there were decisions made that led up to the BP oil spill that prioritized profit, and at least short-term profit, over environmental sustainability and environmental issues. And in the long run, that wound up costing BP so much more money. So considering ESG factors and considerations in making business decisions can, in the long term, both be good for the environment or good for social movements, while also enduring and long-term benefit to shareholders. And so these things aren't mutually exclusive at all. And I have heartburn over all these anti-ESG things we're seeing, particularly from Republican-led states, where they, number one, just fundamentally misunderstand what ESG is. And number two, they forget about the power that corporations have. And number three, they forget that the corporations serve the shareholders. And so the shareholders are the ones who are ultimately, to whom the directors and the officers are ultimately accountable. And so if something is important to the shareholders, then we have lots of data that indicate that environmental, social, and governance issues are critically important to shareholders, particularly as we're seeing the millennial generation and the Gen Z generation move into the investment space. That these issues are important to these communities, these constituencies, and failure to act in furtherance of them will come at long range cost to the corporations. And so that they're not mutually exclusive, and that they should be understood and treated quite harmoniously.
Thank you for explaining that so clearly to all of us. We are moving on to question 6. Do you still have time?
Yeah.
Thank you. What does it add to the existing body of literature in this field, the scholarship that you have produced? And I want to commend you for your articles, both on Bostock and Rainbow Washington.
So I think we've already talked about this in the extent that I don't think I'm the only person writing about this, but I think I'm one of the few that are actually blending these issues together.
Right.
And so that's what I think is the contribution. It's an invitation for us to think about corporate law in terms of its social justice implications.
Which is huge, at the forefront of such an amazing movement. I want to congratulate
Thank you.
It's huge. And I know that you're moving forward, you have a permanent position,
Yes.
but law schools out there, just to be aware of the force of Professor Rice.
And I want us to think about the role that lawyers have
Yes,
in this, because these movements necessarily involve lawyers doing what lawyers do. And lawyers are a profession that have a very unique power and a very unique skill set to bring about these changes. And so lawyers should be willing to file these lawsuits. Lawyers should be willing to take these fights up, because it's part of the power and the trust that's been entrusted to the profession. And lawyers doing this work is going to be key to accomplishing the overall goals.
again, I'm going to commend you on these words, because I think professors like you are rare. And I would like to invite more faculty members to teach their students about the power they have to promote social change.
Yeah. And one
So
thing
thank you.
yeah, and as we talk about that and think about it, one thing that I hope my scholarship will go to is looking at all these anti-LGBT bills that are coming up really across the country in disturbing amounts. And I know that you interviewed our colleague and friend Bruce Ledowitz a few months ago, and he made a comment that just struck me. Is he said that after Obergefell, which of course is the same-sex marriage case, that people just accepted it and moved on. And I don't think that statement could be any more fundamentally wrong. And if you think about the fact that immediately in the wake of it, we had a court clerk in Kentucky who was refusing to issue marriage licenses, and she had to be arrested in Kentucky, changed the law. And you had politicians rushing to Kim Davis's side to protect her. And then you had a wave of states that were immediately trying to redefine marriage and then completely buck Obergefell. And of course, now that we see all the bathroom bills, the don't say gay bills, the particularly heinous attacks on the transgender community based on medical care, and I think really despicably the anti-drag laws that we're seeing, where you see politicians trying to define the LGBT community as in and of itself explicit and obscene and just deviant. I think we have to recognize the particularly troubling environment that we're in. And again, once again, coming back to corporate laws, recognizing the power and influence that corporations have in that conversation.
Thank you again for pointing out this indecent society we live in, and the work that is ahead of us, and ahead of our students. So again, I'm so glad to have you here. So what do you think? There is a conversation. I'm going back to my questions that we all know. They are, I developed them based on Proust's questionnaire. So I'm trying to make them as palatable to our law community. So my number 7 question: how do you think its publication has affected your teaching and scholarship so far? So the publication of all your scholarship, and I see that you have the Queering of Corporate America. You mentioned that you didn't write it, but I think it's
written by Professor Carlos Bell at Rutgers Law. And he's really been an extraordinary leader in talking about the intersection between the LGBTQIA plus community and constitutional law. And, this was a book that was very valuable to me as I wrote Rainbow Washington, because Professor Bell both provided some historical context, but he also was kind of giving me some foundation for the constitutional implications of where this is going.
So what have you added to your scholarship?
Yeah, and I think it's difficult to
I know, and
add it to my teaching.
Correct, into your teaching, correct.
Again, I think that's a difficult question to answer, because for me, teaching and scholarship are really part of the same undertaking of developing the profession. And so they naturally inform each other. And I think the reason that I felt so compelled to get into the technical aspects of fiduciary duty law is because I teach business associations. And I expect my students to be able to articulate these nuances and distinguish between care and loyalty. And part of me teaching them is that I can do it myself, and that I'm constantly thinking about it. I'm thinking about where the law in this area is going to go.
I think that's the sign of an excellent attorney. And I'm sure your students are so lucky and are going to learn so much from you. Moving forward, what are you working on right now?
So I am.
If you are in a rush, the other question is, what would you like to work on?
We get done.
So who you got? Okay.
Yeah, as long as I'm walking out the door at 12:58.
Okay.
So what I'm working on now, I actually have 3 things that are kind of live projects right now. The first is a follow-up piece to rainbow washing. And it's a piece in response to a lot of the responses that I got when I've been presenting it of people who are generally not members of the LGBTQI plus community who are saying, but isn't this corporate speech? Isn't just the fact that these corporations are giving public attention to issues of LGBT inclusion? So like, isn't being deceptive, but even the fact that they're doing it, doesn't that have some value? Mm-hmm. And would I prefer no speech to deceptive speech?
Absolutely.
And it's an intriguing question, because we do have to recognize that in the 1990s and the early 2000s, the LGBT community found a lot of legitimization in the commercial space. So we had commercials featuring same-sex couples. We had television shows like Will and Grace or Dawson's Creek that revealed this. And you could throw lots of criticism at these television shows or these commercials for not accurately depicting what the lived experiences of the community are. But the truth of the fact is, it did probably make some kids in Kansas's life, probably made that kid's life better to see that. And so there is a balance there that we need to walk about. Is the value of the speech outweighed by the deceptive harm, the harm of the deception? And if it is, how do we measure remedies? Mm. How do we measure them, particularly if in the traditional sense of corporate law that, in corporate law, traditionally, the way we measure damages is the stock price goes down. There's financial harm to the corporation. But corporate law doesn't provide a good mechanism for measuring and accounting for dignitary harm. And so that's kind of the rainbow washing part 2 piece, is this exploring the problem of the expressive value and the dignitary harm that's associated with these sorts of deceptions, and thinking about what I think maybe you and I we're like, oh, it's deceptive, it's bad, it's exploiting a community and people who care about a community. But does it give value? Does it help legitimize the community for people to be able to say, well, CBS says this, so it must be true? And I think the answer that I will reach, and the answer that my gut tells me, is that we kind of run into a banality of evil problem.
Hannah Arendt.
And we run into a problem where the harm here is the nothingness of it. The nothingness in the face of an outright attack against a community. And so to give empty lip service and present this idea that everything's okay, so the bathroom bill is not a big deal, or everything's okay, so we can have Don't Say Gay. So I think essentially what this piece is going to say is, not only is the rainbow washing deceptive, but it's distracting.
It's distracting, I think, is malign in the fact that it destroys, again, the trust we have in a particular system.
Precisely. So that's kind of the big think piece that I've got going. The second
Please
one.
use us here with the research.
Oh, I will. The second project that I'm working on, I've presented it as a CLE twice, and I really want to develop it into a paper, is to take this phenomenon of, or not even phenomenon, but this trend and new practice of ESG and compare it to a lawyer's fiduciary duties and advising clients and performing the lawyer's work. And basically, I'm dubbing it right now ESG and ethical lawyering.
Wow.
But I don't know if that'll be its final title, but I want to think about, we can talk about, and the rules tell us that a lawyer serves three functions: a client representative, an officer of the court, and then a public citizen. And we've developed a lot of our understanding of what client representative means. We've developed a lot of our understanding about what officer of the court means. We've paid less attention to public citizen. And I'm thinking that's where we might see the comparison to ESG and corporate managers and ESG and lawyers. So I'd like to develop that and pursue that more. And then another article that I just feel a personal responsibility to write, and I feel a sense of immediacy on this, is to write an article that documents and criticizes a lot of the assumptions and the arguments being made in favor of the anti-LGBT legislation that's being pushed through in my home jurisdiction of Tennessee and in so many other states. And I listened to the floor debate about the recent, where they're calling it the anti-drag bill, or the drag ban in Tennessee. And I listened to the floor debate and just recognized that there's so much misinformation. But when it comes to an understanding of law, and the things that we're really trained to, there's a fundamental, either, I don't know if it's fundamental misunderstanding or if it's willful ignorance. But I feel an obligation to document the arguments that are being made and refute them. And that is something that I feel I need to do sooner rather than later.
I think so, because I have noted, and maybe many of us here, and those of you who are going to listen to us on YouTube, the misinformation about the children going into schools and demanding a litter box because they're just pure fabrication.
Didn't happen.
It didn't happen, and everyone used it at the level of the federal Congress.
Yeah.
And it didn't happen.
Yeah, just an outright lie.
Outright lie, just to destroy the public perception or the interest or the truth surrounding the LGBTQIA community.
Yeah. And it's so interesting. And one of your library colleagues actually wrote an article, and I've got it cited in Rainbow Watching. Who was that? Jim Donovan, who wrote about One Inc.
Correct. Yeah. And he is my co-author in one of the articles, a good friend.
So he wrote a fantastic article about the fact that once upon a time, not too long ago, just the mere fact that something was homosexual in nature, even if it was not sexually explicit, if it were a same-sex couple, was labeled as obscene under federal law, and so it could not be sent to the U.S. mail system. And in One Inc., the Supreme Court, they did not decide this in the context of the LGBT community, but One Inc. did involve sending sexually related materials through the mail. And so, the fact that it's about sex doesn't make it obscene.
Absolutely.
And the following cases that we saw defined our understanding of obscenity law, and we get this incredibly vague prurient interest that is so tailored to community standards. And
I know it when I see it.
Yeah, just all these things that we talk about these things like they're so well established, but really what they do is they serve as proxies for other values and an opportunity to oppress marginalized communities. And that's really what all these bills are doing. Is it's not an attempt to protect children; it's an attempt to oppress and marginalize a community that's already vulnerable.
And that's why we have to speak up and speak out about it.
It is. And,
speak against.
Once again, I view that as perhaps a special responsibility in the position that I occupy as someone trained in the law, someone who's entrusted with the title of scholar, and someone who's a member of the community myself. And that kind of goes back to where we started about why do you write? It's because I have something to say. And there are things that need to be heard.
I love that. Yes, quite often people don't write what needs to be heard because we are embarrassed or for short-term benefit or fear of repercussions. So
I'll tell you, Donna, that this is a matter for people. This is a matter of life and death.
that is
People are going to die because of this legislation, and people are going to die because of the way these people who currently occupy power behave. And that is something we cannot let history erase.
Oh, absolutely, we cannot let that happen. Thank you so much. So what would you like to write about?
All these things. All these, I'm a rebel rouser. So, no.
So the final question, what would you like to share with your students as a final thought and with us here and with your viewers?
Yeah, it's something that I tell every single class that I have, and I think it's relevant to students learning the law. I think it's relevant to students who are writing, and I view my students as they're already members of the legal profession. And this is a profession that occupies a position of power. And students are going to have to figure out how they're going to use that power. And in a moment where I was struggling with some very deeply personal decisions and choices, a very wise friend told me that not deciding is a choice.
Absolutely.
And I think by not taking a position, not entering into the fight, hiding from it, that's a choice. And so I want my students to recognize the power that they have. And I want them to feel a conviction to use that power to make this world a better place.
Thank you. So the personal is political, and it has always been.
Yeah.
I want to thank you very much.
It was fun.
It was wonderful. If there are any questions, no questions. Thank you very much. And we'll be here to help you.
And I want to commend you, and I want to Katie and Amy for creating a space that is intentionally designed for conversations like this. Yes. Because it's so easy when we're busy. It's so easy when we have different hours and we're coming and going. When we don't have maybe a work in progress that we're ready to share. It's so easy to overlook one another as people who have a scholarly profile and have a philosophy, and they're here to do something. And we get so task oriented that it's good to have space where we get to figure out who each other is.
My hope is to have the library as a space where we experiment with our ideas, with our projects, and maybe even reach a laboratory of unnecessary thoughts.
A laboratory of our identity. Yes. This goes straight to the question of who we are.
So thank you, John.
Yeah, thank you.
It was illuminating, and this is the end. See you all with Professor Hepner next month.
Okay.